Welcome to this session, Policy and Practice. It's part of our Policy and Practice Week on trends in US, European and global shareholder litigation. We're lucky to be joined today by Darren Check, who's partner at Kessler Topaz Meltzer Check, LLP, and Richard Pilsworth, who's the General Counsel at the British Airways pension scheme. This should be quite an interesting session. I'm Craig Rimmer. I'm the Policy Lead Master Trust and Standards here at the PLSA, and I'll be chairing this session. And just to set the scene, really, the PLSA has taken a great interest in issues of stewardship generally, looking at voting guidelines, and we produced our own voting guidelines on this issue, because pension schemes do feel a greater responsibility to be more active in a lot of these issues, and their members are actually asking for this. And this is why we've produced the voting guidelines that doesn't just look at voting, but also looks at engagement as well. Also, key issues that keep coming up are in relation to ESG, the environmental, the social, and the governance, and looking at diversity and inclusion and downstreaming of that. But we've also taken stands in respect of remuneration of directors and the board as well. And obviously you would have seen us over the time coming out with positions on that and talking about how to vote on that as well. Pension schemes are becoming more active. And today, this subject, in terms of shareholder litigation, obviously is another angle on that, another aspect of that particular level of pension scheme activism and stewardship. So without any further ado, I will hand over to Darren Check, who's a partner at Kessler Topaz Meltzer Check. Darren.
Thank you, Craig. I really appreciate it. Good afternoon, everyone. I'm really happy to be here with you today, and thank you to the PSLA for the opportunity, to Craig for facilitating, and to Richard for participating. I know this is not the most exciting topic for many of you, but shareholder litigation is an increasingly important and increasingly complex issue, and it's a powerful tool in the ESG toolbox. My goal today is to demonstrate the value of these cases to pension funds and the need to ensure that your fund has the best possible service provider and counselors in place to guide you through these opportunities as they arise. Molly, can we have the next slide, please? So this first chart or slide here I'm going to show you gives you an idea of the number of federal class actions that are filed in the United States every year. And as you can see, since 1996, the number of publicly listed companies declined quite a bit, and then saw a rise in the latter part of the last 10 years. But the number of class actions has remained pretty consistent. We saw a big surge in 2017, 18, and 19, and after years of increasing numbers in 2020 and 21, we saw some declines, with 2021 actually setting up to be one of the lowest number of cases filed in the last 10 years. Now, it's almost without question that this is a direct result of the pandemic. While the markets suffered initially, they have been propped up since then with low interest rates and stimulus money. And a bull market oftentimes hides wrongdoing and prevents shareholders from realizing damages from cases of fraud. But regardless of that, there are still hundreds of cases filed every year in federal court alone. And so any investor with exposure to US equity or fixed income needs to be aware of these cases and what they mean for them. Can we have the next slide, please? So the basics of US class actions. A securities class action is a lawsuit that's filed by investors who bought a company's publicly traded securities within a specific time period, referred to commonly as the class period, and they suffered an economic loss as a result of a violation of the federal securities laws. Now, these are the headline-grabbing cases that you've heard about over the years: Enron, WorldCom, Tyco, Petrobras, Bank of America. These are the big cases that result generally in pools of money that go back to investors. The cases are led by a lead plaintiff, which consists of one or a small group of investors. Frequently, certainly in the bigger and more high-profile cases, these will be institutional investors as lead plaintiffs, such as pension funds. In the last decade or so, European and UK pension funds have become active as lead plaintiffs in US litigation. I would tell you that there are very few high-profile class actions in the US now where there's not at least one or sometimes more UK or European-based pension fund that is seeking to be a lead plaintiff or is appointed as one of the lead plaintiffs in these cases. All investors who purchase their shares during this particular class period are automatically class members unless they proactively inform the court that they do not wish to be. Now, this is very different than what we see in almost every other jurisdiction except for Canada. We'll talk more about shareholder litigation globally, but you're automatically part of the class in the United States unless you affirmatively step out of it. So with hundreds of cases filed every year and between 50 and 100 settlements a year amounting to billions of dollars, trustees have to ensure that they have the best systems possible in place to identify, track, and monetize these class actions. While it's certainly not a fiduciary duty to be a lead plaintiff or be active in US litigation, it's very arguable, and many attorneys and others would tell you that it is a fiduciary duty to collect money that's available through settlements or judgments that come from class actions. Next slide, please. So this is just to give you an idea of the types of companies that we're seeing having shareholder litigation brought against them. It's many of the largest companies listed on US stock exchanges, and some of the frauds that have been committed here are very high profile wrongdoings, if you will. Luckin Coffee was the Chinese company that essentially cooked the books and had 400 million of their $450 million in revenue that was fake. Goldman Sachs related to the 1MDB scandal, Allergan to price fixing in generic pharmaceuticals, and the list goes on. But as you can see, there are, of course, a number of smaller companies, smaller value companies that these cases are brought against, but there are a number of actions against many of the largest companies listed in the US. And some of these cases have either settled or in the process of settling for hundreds of millions of dollars in money that will go back to shareholders. Next slide, please. So what does that mean, the settlements? We talk about money coming back to investors, and I think there's, oftentimes been a thought that I'm going to fill out all this paperwork to get, a check back, and it's going to be for $1 or $10, and I'm going to do a lot of work not to get a whole lot back. That certainly can be the case in some settlements. There are small settlements out there that you'll do the paperwork and you won't receive a lot of money back. But the reality is, and as you can see from this chart, that over the last 10 years or so, there have been multiple billions of dollars available in settlements to shareholders. And we have clients that get back tens of thousands, hundreds of thousands of dollars, and even millions of dollars in one settlement alone in some of the larger cases. Now, obviously, the size of the recoveries that you're going to get are going to be dependent on the size of your positions in the company and the size of your fund overall. But for any institutional investor, I should say almost any institutional investor, if you have exposure to US equities, you are going to have significant recoveries from US class actions if you are filing your paperwork on a regular basis and doing what you need to do. I can tell you that for my firm, many of the relationships that we developed in the early 2000s with European investors were based on the fact that when we met with them initially, they told us that they were throwing their claim forms in the trash, that it seemed like too much work for not enough recovery. And once we started helping them and filing those claim forms, and they saw the tens of thousands, hundreds of thousands, and millions of dollars they were missing out on, it was a real wake-up call. Now, in this day and age, most investors have some mechanism in place, whether that's your custodian, a third-party provider, or a law firm that's looking over this. But I would tell you that this is an issue that needs to be revisited on a regular basis to make sure that whoever you have in place is filling out the paperwork properly, is getting the money back to you, and that they're getting recoveries from all settlements that are available, because there is a lot of money out there to be recovered. Next slide, please. So not every case that's brought in the United States when it comes to shareholder litigation is simply seeking a financial recovery. For many years, shareholders have used state court litigation, primarily in the Chancery Court of the state of Delaware, which is known to be the primary place of registration for most companies listed on US exchanges, to effect meaningful corporate governance changes at companies that have essentially lost their way. This was traditionally a venue for small institutional investors and retail investors, but recent years have seen many of the largest pension funds in Europe and the US taking an active role in this type of litigation and leading them in many cases to some really substantial results. And I'm talking about pension funds like AP7, PGGM, APG, CalSTRS, the New York State Common Retirement Fund. Many of the largest pension funds in the world have gotten involved in shareholder derivative and transactional or M&A litigation, merger and acquisition litigation. These are cases that oftentimes do result in some pool of money that will come back to shareholders, especially if you're talking about a transactional case. But more importantly, they are the institution or the pension fund stepping into the shoes of the company to bring claims against wayward officers, directors, or third parties that the corporation itself might otherwise not bring. Now, why wouldn't they bring them? It's because it's generally the people that are running the company that are doing something wrong. They're not going to hold themselves accountable. As I mentioned, these kind of actions can result in meaningful changes in corporate governance policies and financial recoveries. The types of changes that we regularly see are director nominations and elections, putting new directors on the board, proxy disclosures, increasing what the company is disclosing and how it's doing certain things and what it's doing, changes in executive compensation policies, changes or additions of audit and other risk policies, and even sometimes splitting the chairman and the CEO position for companies that have that. And we've seen litigation now against stock reclassification as well, where, and I'll talk about this in a little bit, where companies are trying to add additional stock classifications in order for founders to maintain control of companies in perpetuity. And then you have transactional M&A litigation. You know, mergers and acquisitions can obviously be great opportunities to increase value for shareholders, but they also present instances of self-dealing and dishonesty by directors and officers, which are generally at the shareholders' expense. And that is instances of mergers or an acquisition of a company where the founders, the directors, or the insiders are getting a much better deal at the end of the day than the regular shareholders, pension funds, retail investors, et cetera. So oftentimes we can get an injunction against a pending merger to change its terms, or we can even get relief for shareholders after a merger or acquisition goes through. And this can mean hundreds of millions, or we've even recovered billions of dollars in these instances where the price increase results in cash payments to the investors. But again, I think, you know, the most important part of this kind of litigation are the types of changes you can make at the company. In the US, unlike other jurisdictions, there's not a lot of dialogue going on with companies. Unfortunately, the stick is more useful than the carrot in many instances. And I think a lot of institutions have found that the courtroom is a place where they can really affect change in a company. Next slide, please. So just some quick overview of some recent cases that we've seen in this arena. These are all cases that have been led by large institutional investors. Facebook is a case from a couple of years ago where Mark Zuckerberg planned to have Facebook issue a series of Series C non-voting stock to essentially cement his control over the company for life. This was a result of him entering into the Warren Buffett giving pledge, where he had to give away most of his wealth during his lifetime, but that meant selling shares that would take away his ability to control the vote of anything at Facebook. What he did was he tried to issue these shares, which was a major detriment to A and B shareholders. After taking the case literally 2 days from trial in Delaware, they dropped the proposal and decided not to issue the C shares. The Google case is a case where there were significant allegations of sexual harassment at the company that the company was essentially sweeping under the rug. A number of institutional investors brought a derivative action. They settled that case with a new diversity council, bringing in outside experts to work with Google, and a $310 million funding commitment to address these issues of sexual harassment and other internal issues at the company. The GCI case is an interesting case where we were able to increase the value of a merger by $110 million. That money is all returned to shareholders. John Malone, who some of you may have heard of, he's kind of and they call him a internet cowboy here in the United States. He's known to buy and sell cable and television companies on a regular basis, and is always looking to make more money for himself than shareholders. And so we were able to increase the value of that transaction for shareholders. And Activision is the latest case. This is the video game company, and some of you may have seen the headlines in recent months about accusations of a college fraternity culture at the company, allegations of sexual harassment and other improprieties. And this is an interesting, recent development where we've seen 3 of the largest pension funds in Europe and 2 or 3 of the largest pension funds here in the US all file derivative actions against Activision, looking to hold the company accountable and change some of the activities at the company. The interesting part here too, of course, is that most of the time when the information about these activities come out, of course, the price of the stock drops. So what you're trying to do in changing the corporate governance and the structure of the company is to increase the value of the company and, of course, increase the value of your holdings in the long term. Next slide, please. So I'm going to turn now to the last piece, which is international shareholder litigation. So this is an area, I think, of shareholder litigation that's giving investors the most headaches these days. For the most part, when it comes to US litigation, if you put a good system in place to file your claim forms and make sure that you're aware of the cases that are out there, you are covering your fiduciary duties. There are some very good service providers out there that can help you with that, and it's not that complicated to deal with. But the international space is quite different. These cases are increasing in number. They're increasing in the number of jurisdictions where they're being brought. And with litigation funders, different rules in each jurisdiction, multiple groups pursuing the same claims, and more, investors are generally left confused and with a lot of questions. So this first slide here is an interesting chart. I know there's a lot of different countries listed and a lot of colors to follow here, but I think the basics is what it shows you is that the number of cases is significant, and the number of jurisdictions where they're being brought is significant as well. The numbers have remained somewhat steady. We've seen some increases over the years, but these cases are not going anywhere, and they are increasing certainly in number. Can we go to the next slide, please? So class or collective actions outside the United States, as I said, are increasing in number and jurisdictions. The term class action being used outside the US is really a misnomer. Almost every case outside the United States, except for Canada, is an opt-in jurisdiction. And what that means is that if you don't do something proactively to join the litigation at the beginning, you cannot share in the recovery at the end. Now, sometimes that's as simple as signing a retention agreement. Sometimes it's a lot more complicated. It involves a funding agreement from a litigation funder, an agreement with a local law firm or arbitration firm, et cetera. So there are a number of serious considerations when deciding whether to join an action and which action to join. As I'm sure a number of your funds have been faced with, in many of these jurisdictions, it's not just one law firm or one group that's pursuing these. A couple of years ago, a very good example of that is Danske Bank. Of course, the largest bank in Denmark was caught up in some money laundering allegations. Not surprisingly, there was a lot of litigation brought in Denmark against them. There were 6 different groups pursuing 5 different sets of claims and class periods in Denmark. That's a lot of information for a pension fund or other institutional investor that doesn't do this for a living to parse through and understand. Prior to 2010, almost all shareholder litigation was brought in the US, regardless of where the defendant company was domiciled. But there was a landmark case in the Supreme Court here called Morrison versus National Australia Bank, which essentially said that you can no longer bring claims in a US court unless the security was bought on a US stock exchange. That is what really led to this huge increase in cases outside the US. What the Chamber of Commerce here in the US was trying to accomplish essentially was eliminating a lot of litigation against companies that were domiciled outside the United States by preventing you from bringing a case here in the US. unfortunately for them, I should say, the result was that lawyers found ways to bring these cases in other jurisdictions, utilizing laws that were already on the books that were rarely being used, or by actually having new legislation created in some of these jurisdictions to allow these types of collective claims, litigation, funding, et cetera. So with the increasing visibility of these cases, there's a need for pension funds and all institutional investors to evaluate and participate in these cases under the right circumstances. The next slide, please. So until a decade or so ago, any shareholder litigation outside the US generally involved smaller companies and resulted in minimal recoveries for shareholders, to the point where there was very little participation, certainly by institutional shareholders, and really very little participation in general. But now we're seeing claims for billions of dollars against many of the world's largest companies and recoveries that are in the hundreds of millions or billions of dollars. And so this slide, you can see, these are all names that I'm sure you recognize, companies throughout Europe, South America, Asia, where cases are being brought against them for violations of shareholder laws in their particular jurisdiction. Volkswagen, probably the biggest of all of these cases, and maybe the most high profile and well known, has been being litigated for, I think, 4 years now in Germany. Unfortunately, not a real end in sight for that case, but certainly you can see here many other companies. RBS, a case that resulted in over $1 billion recovery. Fortis Bank, another claim that resulted in over €1 billion recovery. And many of these cases, Mitsubishi in Japan, Petrobras in arbitrations in Brazil, BHP in Australia, all cases that have significant involvement from pension funds and other institutional investors, and all cases where the claims are in the billions of dollars. Next slide, please. So I've talked about a couple of these things already, but the complicating factors of non-US collective actions. How do you find out about all these different actions, the different groups pursuing them, identifying and retaining local counsel and the right litigation funder? You need to proactively join these cases. Some of the logistical challenges, dealing with time differences, potential travel, language barriers, discovery obligations. What is involved in being a plaintiff in these cases? Are you just a passive member of a group like you would be in a US action, or are you going to have to provide documents or testimony or other things in order to maintain your status as a plaintiff? We recently saw in the Tesco case in the UK where a number of investors had to have their portfolio managers actually provide testimony. They weren't told that at the beginning of the litigation. It was a very complicating factor for a lot of investors. So really important to know what you're getting yourself into in these cases before you go into it. And having a service provider that has that legal expertise is a real important part of that. And then, of course, additional costs. There are jurisdictions with loser pays. Are you making sure that you're covered in that aspect? You're dealing with hourly and not contingency fees, less developed securities laws, and unknown variables like judges that have never seen these kinds of cases before, cases of first impression, and then increasing budgets. So another thing that you have to be careful of are the lawyers and the litigation funders properly funded to actually litigate a case for years on end. Next slide, please. So just a quick look at some of the recent cases that we've seen overseas. The Nissan case in Japan, where you had former chairman and CEO Carlos Ghosn arrested for financial misconduct. Of course, Nissan at the very beginning was saying that they had done nothing wrong and that Ghosn was a criminal. Of course, it turned out that there were a lot of very lax corporate governance controls and issues at the company that allowed Ghosn to act the way he did. Standard Chartered, a case that's recently been filed in the UK with issues of false and misleading statements regarding to its compliance with money laundering. Money laundering is a very common theme that we see in a lot of litigation that's being brought against banks these days. BHP in Brazil, relating to the mining dam that collapsed in Brazil and sadly killed a number of people. The Steinhoff case, which I believe was referred to as the Enron of South Africa, another case that's resulting in billions of dollars in losses, a company that has managed to stay afloat and is potentially settling some of those claims in the coming months. And then, of course, Wirecard, which I think was then referred to as the Enron of Europe, another company that saw massive losses and then went into liquidation. A complicated but potential way to recover money in that liquidation, in that bankruptcy. Again, something that any fund that has investments there needs strong legal guidance on how to best make their recoveries. Next slides, please. So just to give you an idea, I mentioned that some of the settlements here in international litigation have really increased their significant amounts of money. And as you can see here, I mentioned the Fortis case and the Royal Bank of Scotland case, both over $1 billion in recoveries. And then a number of other cases, in the Netherlands, Australia, the UK, Japan, in the tens or hundreds of millions of dollars. All of these are recoveries that if you did not actively opt into the case at the outset, you cannot get any of these recoveries. And that's really important. The Olympus case, I'll use that as an example. It's a case that my firm actually litigated. The $92 million may not seem like a huge recovery, but the fact is that it was a very small group of investors. This case was at a time when litigation in Japan was a bit of an unknown, and the investors there got over 80% of their damages back because they were such a small group and we were able to recover such a significant amount of money. So when you don't participate, it really is to the benefit of other investors. Next slide. So what are the key takeaways? I'm trying to be mindful of my time here. The key takeaways from today, from what I'm trying to get across to the group here, the litigation landscape is expanding rapidly. There are a growing number of cases related to both shareholder and antitrust in a growing number of jurisdictions. We didn't really get into much detail about antitrust, but I'm sure all of you are aware of the major settlements when it comes to LIBOR and FX and ISDAFIX and these other financial instruments, financial indices. And these are very significant settlements that what we have found is that most service providers are not filing claims for their clients in those cases. They're leaving it up to the clients. There are billions of dollars that have been recovered here. We can spend a whole separate webinar talking about those cases, but something that you should be aware of and making sure that you're covered in that area. Increasingly, your pensioners are aware of these actions and asking those that oversee their retirement savings to pursue these recoveries. They're seeing these cases in the newspaper, they're seeing them on the daily news, and we hear very frequently from our clients that they are getting inquiries from their pensioners of, have they joined the case in Volkswagen against Germany? Are they getting part of some settlement in Luckin Coffee in the United States? Did the pension invest in that? So there's definitely more awareness of these cases and the settlements. Ensure that your organization has a significant understanding of these cases, how they affect your investments, and what you need to do to ensure you're recovering assets is of paramount importance. Retaining a service provider with significant experience in these areas that can also provide legal advice will add a great deal of value and provide peace of mind that you have proper coverage in this important area of stewardship and financial responsibility. I can't suggest strongly enough that putting a litigation policy in place, having a proper service provider in this area will make a big difference for your fund, not only in getting recoveries, but certainly in your ESG toolbox. I had provided a link here for an article that one of my colleagues wrote on what you should be looking for in a service provider. As I mentioned, there are good service providers out there, not just my firm. And it's something that every fund should be taking a look at of what's the best fit for them to make sure that they're covering themselves in these areas. And the last thing I've kind of said this is, but formalize your process. Put something in place that's not just being left up to your custodian. Know what you're doing internally and make sure that your outside counselors are on board with that. So I could go on for 2 or 3 hours about all of these different topics. I know we went through everything very quickly here. I'm always available to answer any additional questions that you have, either here on the webinar or otherwise. But I'm going to turn it back to Craig really quickly so that he can get to somebody who's living this day to day, one of the practitioners, Richard Pilsworth. So I'll turn it back to you, Craig.
Yeah, no, thank you, Darren. And I totally disagree with you. That was fascinating. So when you said it wasn't the most interesting of subjects, I was absolutely enthralled by that. And
thank you.
Some of the extra value that pension schemes could get by actually participating in these in this litigation. But as you say, Richard Pilsworth can speak to the pension scheme perspective and looking at that from that angle. So over to Richard, please.
Thanks very much, Craig, and good afternoon, everyone. So yeah, I'm General Counsel at British Airways Pensions. We've got two large defined benefit pension schemes with about 27 billion in assets. So one of the larger UK schemes, and yeah, so we're quite active in the class action space. And I'm going to be looking at sort of class actions today from a more practical perspective for trustees. So sort of how you set your policy on class actions and then how you actually manage it. Next slide, please. So the first thing we did was actually go to our trustees and basically ran a workshop to understand what their appetite was to participate in class actions. You know, what does it actually mean in practice? And this is actually litigation after all. And the conclusion that our trustees reached was basically, why not maximize the returns that you can get from the assets that you hold? So, put a very sort of positive message in response from our trustees, but that doesn't mean that there aren't some kind of expectations and misconceptions that you probably will get if you have that kind of workshop. So Darren has talked quite a lot about the difference in the opt-ins and opt-outs and the different kind of levels of work that's required, but just making sure that they understand that is important. Common question is this one about, doesn't the class action destroy the value of the company you've disinvested from that company?
Sorry, Richard, you dropped out that last sentence where you started with common question.
Right. Okay. Sorry. Yeah. Okay. So, so the common questions that you might get, and just trying to manage the expectations and misconceptions. So, Darren's spoken quite a lot about the difference in the opt-ins and opt-outs, so I won't go over that again. But the common question about the class action destroying the value in the company that the trustees invested in, that's I think generally you've actually quite often disinvested from that company. So actually then bringing a claim against it isn't going to drop any kind of value from your perspective. But even if you were still invested in that company, everyone else is going to go into this class action. So why should you be the only person who doesn't get some kind of recovery there? The idea of, I think one of the trustees called it just free money up for grabs. Why aren't we doing this? So I thought that was a good and sort of nice perspective on it. But I think it's sort of a yes and no. Yes, it is free money, but there is some work to be done. So just making sure that they understand that is important. The litigation risks are something that you could actually end up having a kind of policy on. So you could kind of say, well, actually, we like the opt-out space, but the opt-ins is just too difficult for us. So our policy will be, we'll just do the opt-ins, and then we don't have to worry about the costs risk. And then you might also say, well, we only ever want to be a group participant. We don't want to be a lead claimant. And then that final bullet point, that's just, we've talked about the sort of stewardship and ESG perspective, which is increasingly important. And then once you've got your policy in place and you've decided you want to do these class actions, you need to, as Darren said, sort of select and appoint your service providers. My experience is that your investment manager and your custodian will not do this for you, or they will provide a very, very limited service. So you can't just rely on them doing this. So the two big areas are the sort of claims filing and claims monitoring services. And so the claims filing is very much more on the opt-out side. Claims monitoring is opt-in and opt-out. And there are some sort of one-stop shop services, some intermediaries kind of sit between you and the law firms that actually kind of run these claims and kind of claim that they will manage it for you. In my experience, it wasn't actually something that added a lot of value, to be honest, because you ended up having to do a lot of the work yourself anyway, and really they just became a kind of mailbox that kind of passed on a message from one side to the other. And we've had a lot more fruitful relationships, sort of acting directly with the law firms that are involved. And we do, it'll be heretical to say from Darren's perspective, but we do use KTMC as our sort of primary service provider, but we do also kind of just make sure that we are hearing from other law firms just to make sure we're not missing anything. I'm sure we wouldn't, but it's just always interesting to hear a sort of wider perspective. Okay, next slide, please. So now you've kind of set up your policy, you've decided how you're going to run it and what you're going to do. So make sure you document it, obviously, and then you start managing it. So on the sort of opt-outs, setting up you've obviously set up your claims monitoring service, and that will require a kind of custodian data feed to be set up. The custodians are all kind of very good at helping to make sure that basically a daily feed goes from you to the relevant kind of law firms who you're using, and then they can basically monitor that data feed and decide whether you held the shares at the relevant times in the class period. And then we also do our own internal monitoring. So we sort of keep our own spreadsheet of all the claims we're in, the recoveries we've had, what stage they're at, just to make sure that we're on top of what's going on. In terms of the opt-ins, that's obviously is quite a lot more work, but we have set up our own internal process and made sure that we kind of keep on top of this. So few of the sort of key steps and some of the more interesting points in this list here. So obtaining the views of the asset manager, and this kind of also goes to the evidence point about investment decision making records. It's a little bit lower down. This is becoming increasingly important. So we do find that the defendant companies are kind of saying, well, would you have actually made that investment anyway, even if you'd known about sort of XYZ corruption or whatever it is, and having some evidence trail to show that the asset manager kind of thought this was a good investment and a clean company is becoming increasingly more important. So hearing from the asset manager up front, just to know that that this was obviously a complete surprise and the market wasn't expecting this, is valuable. The views of the sponsor, obviously in terms of investment policy, your sponsor doesn't have any kind of control over how you sort of run your investments and what you might sort of what litigation you might do, but it is always still relevant. We've kind of, or can be relevant, and a factor that you can take into account. So for example, if it was going to damage the covenant of your sponsor, then you might want to steer clear. So there was a recent Airbus litigation, which we did feel like that was probably pushing it a little bit too far. But we sometimes get some pushback just because a defendant might be a large corporate client of the sponsor. I think we've kind of generally taken the view that actually, unless you're the lead claimant and therefore you're kind of going to be splashed over the press as being XYZ company versus British Airways Pension Trustees Limited, they're probably never going to know that you were in this claim, because you'll just be one of a list of names in a court in a sort of court application. So you can generally kind of get around that with the sponsor. Then in terms of the sort of negotiating the documentation and everything, that is kind of a key part, and we make sure we get legal advice on that. And we kind of assess the different claimant groups to kind of work out what fees are, what the adverse costs protections are, what the funding arrangements are behind that, to make sure that we kind of make the best decision on it. In terms of evidence, the legal standing bit is something that's a little bit bizarre, but we sort of increasingly find that we get these challenges that we just weren't actually owners of the shares. So your custodian can kind of help you with that, but it's a sort of tedious step that seems every defendant seems to do at the moment, just to try and knock out a claim and say that you never held the shares in question. And then managing, once you're sort of in the claim, then you just want to manage those ongoing claims. So make sure you review the reporting updates, what's the progress in the claim, monitoring the litigation costs. I think the RBS claim which we were in, the litigation costs, so RBS's defence got up to 100 million at one point, and we started to get a little bit nervous about the ATE insurance cover. So that was an interesting conversation. And then finally, if you do a settlement, you'll just want to sort of actually decide whether you agree to a settlement and the terms for that. And then the great bit is reporting the recoveries. So that's you go back to the trustees, tell them all the great news that they've got some money back, and that's everything from me.
No, that's great, and this has actually sparked a question from the audience. So I will just ask this. This is from Kate Grant from the audience. Thinking about ESG requirements, are more schemes taking up this opportunity to participate in class actions as a responsible investment decision? So I'll field it to both of you, but we've got about 6 minutes left, and I may ask a question of my own. So over to you, Darren, first.
I think the answer to that is absolutely yes. And I can tell you from my experience in working with a number of pension funds on the continent and in the UK, that almost every discussion at this point involves their ESG designated person at the fund in a conversation about cases. generally the lawyers are involved as well. But almost every decision when it comes to shareholder litigation, except for filing the claims in the U.S., and even there I've seen some funds say, we don't want to participate if we don't believe in the underlying facts of the case. That's a whole different discussion. But for certain, whenever it's about active participation, we see ESG and those kind of requirements coming into the decision making.
And for you, Richard, is that something you look at British Airways as well?
Yeah, absolutely. It was actually, we were sort of involved in class actions before ESG became a really big thing. But yeah, it's very much kind of part of the mix of feeling like you're a good steward of the assets that you hold. You're not an absentee landlord. And as Darren said, we do get questions from members asking, are you in XYZ case? So yeah, it's absolutely relevant. Yeah.
I mean, looking at some of the cases that were brought up, the non-US ones, the Fortis, the RBSs, like quite recently, we actually get decisions on those. It sounds like it's quite a long timeline. What sort of timeline are we typically talking about with these class actions, Darren?
So in the United States, we always tell people it's between 2.5 and 5 years is the general timeline. Some of the cases in state court that we talked about, derivative and merger and acquisition, can actually move very quickly, especially if it's revolving around some kind of transaction. So sometimes you can see those cases resolve in even 6 months. But generally, a rule of thumb is 2.5 to 5 years maximum in the US. Outside the US, it's hard to say. We see cases that have been litigated in Germany for 10 years and they're not over yet. The Danske Bank case in Denmark, for example, is moving at an incredibly slow pace. Most of that is because these courts are simply not experienced in this kind of litigation and in what's involved in proving ownership of shares, bringing in economic experts to prove damages, and that's what really makes them longer to litigate. But I think that over time, as these jurisdictions become more familiar and see more of these cases, you'll see a more efficient system in place.
Yeah, Richard, just to chip in on that. Yeah, I think my favorite one is the Vivendi case that we're in, and I think that goes back to 2002.
Yeah, which we're now on an appeal on that case.
Yeah, exactly. Yeah, testament to the French legal system.
No, absolutely. I guess some regimes are going to be longer than others, as you say. I mean, the key aspect from what you were saying is picking the right service provider for yourself. I mean, how do schemes go about doing that, Darren?
Well, I would say, and Richard can maybe talk about this a little more, and he mentioned it a bit already. To me, it's don't just go with the first person you talk to. It might sound great. There are different levels of service. There are different types of companies that do this. There are the law firms. There are the independent providers. There are some who are just kind of intermediaries. So I would really encourage any fund to go out there and look at a few different options and compare them, and maybe even consider putting out some kind of tender for it. That is something that I had never really seen in the UK and Europe up until a couple of years ago, but we have responded to a number of RFPs from European investors, and it's a good way to see what's out there and compare and contrast.
Yeah, no, completely agree. I mean, I think it's just a question of kind of getting a few ideas of who's in this space, speaking to them, understanding what the costs are, understanding what the service levels are, and kind of getting comfortable that it fits in with whatever your internal processes are, so that you can actually manage it. Because if you're not on top of it yourself, then it's these firms kind of can help you up to a point, but you also have to do it yourself.
I mean, we're looking at value for money a lot as pension schemes at the moment as well. Is this a piece in the jigsaw? Can this actually bring real value back to the pension schemes themselves, would you say? I'll field it to Richard first.
It goes to Darren's point, I think, about the size of the fund that you have and how deeply invested you were in there, what your recoveries will be. I mean, we had RBS was a really big recovery for us. That was about 2 million or something like that. So, that pays for itself, many times over. So, you can really be kind of getting some hefty recoveries. Yeah.
And Darren?
Yeah, I would just say I completely agree with that. There are going to be some big recoveries that come in, and we hear from a number of clients that they will actually set a goal to pay for their legal department with the financial recoveries they get, you know, and or setting goals to be active enough to get recoveries to pay for certain things. So there can be real money that comes back. Certainly, it depends on how you're invested, and of course, and where your investments lie. But there's definitely significant economic benefit. But as a lawyer, I would also have to tell you that you have to weigh that against the amount of work that is involved in some of these cases, and knowing what you're getting yourself into. Not every case is for every investor.
And is it something small schemes can get involved with as well? Obviously, BA is a big scheme.
Absolutely. I think that's probably, and we didn't talk too much about this, but that's probably one of the biggest misconceptions amongst small pension funds, is that I just don't need to worry about this. That's not true. Even if you were to recover the amount of money that would cover the pension for 1 or 2 or 3 of your pensioners a year, for the minimal amount of work that you can do to achieve that, it's certainly worthwhile. So I think that unless you're a pension fund that is completely invested in pooled assets that you don't own, and so that you have no direct relation to a class action, it's something that you should be looking at and at least making sure that you're covered.
No, definitely. I mean, I can't believe we've run out of time. It's just sort of rattled by, hasn't it, so quickly. Maybe we needed those extra couple of hours, Darren, to talk about it. But no, thank you both. Thank you, Darren, and thank you, Richard, and thank you to the audience for participating, and the great question we had in on ESG as well. And on that note, we come to the end of an excellent webinar. Thank you very much.
Thank you, Craig. Thank you, Richard. And thanks to the PLSA. Bye-bye.
Bye.